Okay, thanks everyone for both our lawyers and Ken and his lawyers as well. Thanks in particular to our two speakers for this evening, Puan Susila Sithamparam and Ms. Selvamalar Alagaratnam. Puan Susila is a former president of the Industrial Court, which is a post that she held from 2009 to 2016 and 15. Ms. Selvamala is a senior practitioner, a partner at Screen, a lawyer of over 20 years standing, and no stranger to the firm. And we are very, very privileged and very honored to have both Puan Susila and Sel speak to us this evening on a topic that is familiar to the firm, practice at the Industrial Relations Bar, views from the bench and the bar. And I thought I'd start the session by asking Puan Susila the first question. What led to you becoming a chairman of the Industrial Court?
First of all, I would like to thank Janice, Greg, and all the partners and associates of the firm of Stephen Thiru and Sudhar. I'm really honored to be invited to share my experiences. So coming to your question, when I was working, I was an officer of the Judicial and Legal Service. I did start my career at the bar and I was in practice for 3 months. Then I joined the Judicial and Legal Service. So when I was posted to the Industrial Court, I was coming as an officer of the Judicial and Legal Service. At that point in time, in 2002, there were 15 cadre positions and 6 contract positions. So this 15 cadre positions were newly created sometime in 2001 or 2000. And I was one of the officers from the Judicial and Legal Service who was posted to the Industrial Court. Before my posting to the Industrial Court, I was in the Attorney General's chambers as the Deputy Commissioner for Law Revision and Law Reform. So I received a transfer order which was signed by the Solicitor General and the Chief Registrar of the Federal Court on the 15th of April 2002, and I was given 2 weeks notice to report to the Industrial Court on the 2nd of May 2002, and when I reported to the President of the Industrial Court, I was assigned to Court 21. At that point in time, I had completed 21 years and 11 months in the Judicial and Legal Service in various capacities. So Greg is wondering where was he at that point in time?
Was he even born?
I have no clue myself, actually. Even if I knew, I don't know whether I would like to share it. But Puan Susila, did you enjoy your time as a chairman of the Industrial Court?
Most certainly. I had already found my rhythm in the Judicial and Legal Service, and I was used to transfers and learning things immediately. So I was mentally prepared to learn a different area of the law, and I consider it a soft area, the law. It's not terribly complex. So all I did to familiarize myself with the law was to read the textbooks, and which we had a very good library and all the awards which had been written in the course of the year. So I was quite prepared to start the hearing immediately, because over the years you learn to grasp new areas of the law. We are jack of all trades. So so we do criminal law, we do civil law from the service. So we know a little bit of everything, and it's quite broad-based. So when I was a chairman, initially I heard the dismissal cases. This forms the bulk of the cases in the Industrial Court, and then later I started to hear the collective agreements, which is really a very, very unique area. It's only at the Industrial Court that you get to hear disputes or to craft agreements on collective agreements. And when I became the president of the Industrial Court, I heard mainly trade disputes, collective agreements, and related matters like the non-compliance of awards or interpretation of awards and collective agreements. And when an award had been handed down by me in a dismissal case, I would recuse myself and not hear the non-compliance. So I think my 1 minute is up. But I did a bit of administrative work, and I got involved in the computerization of the industrial court right from the beginning. In 2006, we had the first phase where we did the computerization of the case management modules. I used to brief all the engineers on the court processes, and they translated it to the engineering plans and drawings. So it's quite interesting to see how court work looks on a plan. And then the second phase was in 2014, where we introduced the digital recording system, where speech recognition technology was used. And we started with e-filing and e-service.
And what would you say are the three, or rather, were the three most attractive aspects of being a chairman of the industrial court?
I will say it is the subject matter of the jurisdiction, because it's related to work which is so fundamental to our lives. This is a form of justice which we would call social justice. We apply principles of equity and good conscience, and the precedents we had been developed, in fact, as way back as 1965. So I had a lot of guidance, and we have a lot of jurisprudence from the Commonwealth countries, from India, from the United Kingdom, New Zealand, Australia. So it also has a global perspective, work in a global environment, and that has been my area of interest, globalization. Then the other unique feature is the composition of the tribunal. When we hear trade disputes and collective agreements, it's presided by a chairman, and that's why we are called chairman. And the other members are representatives from industry, one from the employers panel and one from the employees panel. The Minister of Human Resources would select qualified persons to be on the panel for employers and a panel for employees. And at the industrial court, we will match the members from either panel with the chairman.
Thanks, Puan Susila. Sel, if I can pose a question to you. As I mentioned before, you are a very senior practitioner at the Industrial Relations Bar. But have you always been in employment law or industrial relations, or were you exposed to other areas before you settled in the area that you practice in today?
So as funny as the answer may sound, the answer to both your questions is yes, Greg. So to begin with, from my very first day as a pupil in Chambers, I was exposed to industrial and employment law. I chambered in a firm. I don't know how many of the young ones in your firm would have even heard of it, but it's a firm that then at that time was like a household name, called Gingka, Maha, Wong. My pupil master was the late Justice K.P. Gangadharan. He was at that time acknowledged to, people used to say, oh, he's the king of industrial law. So I was very privileged. And in that sense, I started in IR. However, as small as the firm was, because there was another partner, Mr. Mahalingam, he also did IR, but he also did some other areas. So I did very small matters like small commercial disputes, debt recovery. I remember even a horrible family matter I had to do. And it may surprise you, but I did a whole lot of conveyancing because we did have 3, I think, banks that were our standard clients, including Standard Chartered, I remember at that time, yeah. So I did a lot of conveyancing, SNPs and loan documentation. But
all these years, and I never knew that, Sel.
Yeah, so yeah, so then, and I must say that even after I moved to screen, it's not, yes, 90% of my work is IR and employment, but I have somehow or another gotten involved in some large civil matters. So one was a commercial / family feud matter because it was a family run company, and that went all the way up to Court of Appeal. I also do medical negligence. Yeah.
How did you end up applying to Gingka, Maha and Wong, which was a predominantly IR firm?
Okay, so after I finished my CLP, I always tell people I'm an accidental lawyer. I wasn't even sure I wanted to become a lawyer. But when I was, in Form 6 or Form 5 or whatever, there's a joke, right? If you're from a Sloanist family, your options are limited. You have to be a lawyer, accountant, or engineer. So I wasn't about to be any of the other three. For a while, I thought I'll do medicine. Then I realized I'd make a lousy doctor because I'd have no empathy for my patients. So degree and just go into management. So I applied to do IR law. To be honest, my father knew both the partners. But also I thought that if I'm, having some knowledge about HR, because human capital is very important to any organization, I thought it would be relevant experience when I start applying to go and work in some large organization.
Well done, Sel.
And so, what would you say are the three aspects of industrial relations practice that you enjoy the most?
So what I like most about it is the human element, because it's very people-centric, right? It's not like about some shareholders agreement or something. It's something that people are in court fighting really for what they believe are their rights. So I like that. I also like the fact that really no two cases are ever identical. It's not like, again, a lot of other civil or commercial disputes. It's quite, the facts won't be all that different. But with industrial law cases, no two cases are ever identical. And I also really enjoy the fact that when you do industrial law, you actually get an insight into various industries. It's, for example, when I do medical negligence, I learn a lot about medical science and how hospitals are run. But when I do industrial relations, I learn about how banks operate, advertising agencies, manufacturing companies, semiconductor, businesses. It's not at all limiting. So I really enjoy that.
Oh, thanks a lot. Puan, Susila, if I can just turn our attention to you again, and if I can just take you back to when all the documents of a case have been filed, the pleadings are in, the witness statements are in, the bundles of documents are in. What would be the first few documents that you read before the start of a trial at the industrial court?
I will start with the pleadings and I will identify the issues. Then I will read the minutes recorded in the court file, because some questions would have been posed along the way. And also the witness statements. I have quite a retentive memory, so I'll just read it and it will be with me while the case is going on.
And would you normally note down, make any notes whilst you read those documents before the start of trial?
I didn't have the habit of writing notes, but I would use a highlight marker. And as I read and something captures my attention, I will highlight those words. So it has a lot of colors. My documents have a lot of colors instead of pencil notes.
And Puan Susila, after having read those documents and highlighting the documents as well, would you often form preliminary views about a case before the start of trial?
No, I do keep an open mind, because I think that is the best approach. So then I'm eager to listen, because I leave it to the witness and counsel to ask witness to answer whatever questions that the is relevant. And I'm quite an attentive listener. So I listened very carefully to the nuances. I've enjoyed this aspect of being a decision maker, sitting on the bench, listening to each person unravel his version of events. And with that in mind, as the story builds up, I'm able to see the picture.
And so, before the start of a trial, would you often prepare a case theory or a broad overview as to your case?
Yes, at least in my mind, similarly like Puan Susila, I don't write it down, I or type it out. But in my mind, I do have a case theory because I think it's important that we do not lose the plot. And at the end of the day, we have to make a case, right? Even if you're defending, and in the industrial court, those of us who act for management, we are always more or less in a position where we are defending the action. But you've got to make the case, because whether it's a civil case or industrial case, even if you're a defender, and I mean, what's your story? You can't be contradicting yourself. So it's important. I feel it's important to have a case theory.
Would you be able to talk us through how you personally prepare or formulate a case theory in your mind?
Okay, so I generally look at the facts, the events. Wow, I don't know whether there's actually a conscious thought to it, but it's like, when you look at the facts, events, you listen to your client, it sort of comes at you, right? It jumps out at you, and you can tell whether, okay, this is a case where, this employee was really just too much, too difficult, was asking for it, and this is what led to the dismissal. Or is it a case where your own client has been really unreasonable and hasn't managed the matter properly? So I have to confess that I don't have a very systematic approach to it, but it's actually paying attention. I would say pay attention to the facts. Don't have a preconceived idea, like just because the client comes and tells me, oh, we terminated this person for poor performance, I don't necessarily say, okay, we have to argue this case as a poor performance case. I would look at the facts, and then I might actually see that, and it's becoming increasingly common, especially with poor performance. I look at everything and I say, hey, but this guy was also quite insubordinate. So maybe we want to put that in. So I think, pay attention to the facts, the evidence, the things that the client tells you and maybe does not tell you, because a lot of times the client also doesn't realize the importance of certain events.
Do you find sometimes, Sel, that when we prepare our case study, we are very much guided by the Milan Auto twofold test, where, you tend to say, all right, now we need to establish the misconduct. And then once we've done that with our facts and circumstances and witnesses, and then we move on to see whether is the dismissal justified. And does your case study sometimes work in that way? Because sometimes I find myself doing that.
I don't think I do that consciously, Jen. Yeah.
Okay. No, I mean, different people have different styles in preparing their case theory. Yeah.
I think I tend to sort of go with the gut feeling sort of thing.
Okay.
Yeah. I know that's not very helpful.
No. It's just sometimes important for also our lawyers to realize that there are different ways of doing the same thing.
Yeah.
Yeah. So I may do it in my own style, but obviously now you've given them a different perspective of how things ought to be done. So, I mean, or could be done. Yeah.
I can just quickly move on to a different issue, this time insofar as cross-examination. When preparing for cross-examination, do you normally note down in full, in verbatim, the questions you propose to ask, or do you normally just have broad headings and broad topics?
Oh, yeah. So I don't list down every single question. I actually have as you say, the broad like subheadings and subheadings or whatever. but I do spend time creating those headings and subheadings. So in my mind, I know more or less what kind of questions I'm going to ask, and depending on how the answers are, which way I'm going to go. Because I feel that cross-examination is a very fluid thing. Your next question has to depend very much on how the witness answers your first question. So I personally feel that if you prepare your 359 questions, and then you're going to be slavishly trying to ask each and every one of it and start ticking off because you feel you're doing your job well, you're going to miss that opportunity, because sometimes the witness says something which is such a gem, you should jump on it and take that opportunity and kill the witness. I mean, but it's a pity if you think that, okay, I already asked question number 52, now I will ask question number 53.
What would you say to a junior lawyer who perhaps hasn't handled a cross-examination in court before? Would you say writing down the questions would be a good starting point for them to get experience and to become familiar in the practice?
I mean, I would say if it gives them some confidence, maybe yes, it's a good idea to have your questions there to sort of fall back on in case things you freeze or you get nervous. But I think a better thing to do would be to have a vivid imagination. Practice your cross-examination at home. Imagine you're in court. Imagine you have Puan Susila there judging the case, and you've got this witness you're cross-examining, and how you're going to ask your questions, how you're going to, break the witness. Imagine what kind of answers the witness may give, and how you're going to, basically maneuver your way around. I think that would stand you in better state than sitting down at your desk and writing question after question.
Thanks, Sel. Puan Susila, whilst we're on the topic of presentation of a case at the industrial court, what would you say are the three most effective ways counsel can present his or her case at the industrial court?
Well, we have to ascertain who should begin. Let's say it's a dismissal case. We have to ascertain who should begin the case. In most of the time, it's the employer who begins the case, although the workman is cited as the claimant and the employer as the defendant. But in the case of constructive dismissal and forced resignations, it is the claimant who begins the case. So the first thing is to determine your order of witnesses. Who do you want to call? And now, if the employer is to begin the case, then you would want to start with the human resources officer, who will want to establish the chronology of the person's employment. And then if it's based on misconduct, then you will want to call in the supervising officer, who would be able to give details of the misconduct. And if it's the claimant who's going to start a case, in the case of constructive dismissal and forced resignation, it should be the claimant who should start the case, and he should explain the circumstances which, in his mind, led to him walking away or forcing him to tender a letter of resignation. So the order of witnesses will help. If you follow a chronology, also it helps because it makes sense. Let's say it happened over a duration of a period of time. We must be able to see the whole connection from one witness to another. Have a certain logic in what you do. Of course, this is subject to availability of your witnesses. Sometimes the witness is not there, and we just have to go to the next best approach, call in whoever is available. Some people may be not available for various reasons. The court will allow you to call your order of witnesses in your own way. I think that's where counsel has conduct. And of course, being prepared, whatever it is, I think the work that you do the day before, the night before, will help you to focus on the case. You have to have, if you receive a file first thing in the morning, then you're a bit handicapped right? Because you will have to read through the pleadings. That would happen when there's a request for postponements and the court doesn't allow and someone else from the firm has to assist. That can happen. So these are the contingencies you as counsel will have to adapt. But if you have the luxury of doing the case where you're prepared, then I think you have just a cursory reading of the pleadings and whatever witness statements. At least when you start your case, things are fresh. I know everybody is having different kinds of pressures at work, so we'll have to make the best in an ideal situation and in not so an ideal situation.
For Susila, I don't know if you remember many years ago when you refused Stephen's request for an adjournment, for a stand down when he had a matter in the Court of Appeal, and you told me, Janice, you do the trial, you can carry on, I'll give you 15 minutes.
Something. It would have happened many times.
And I just stood there staring at you, and I had to do the trial in 15 minutes.
So it does happen because you see, these are the exigencies of working life. And now when things are returning to normal, I can imagine the courts will be ready to start afresh, especially come next year. Be prepared, have a good holiday, good rest, but be prepared to work hard in 2022 because the backlog would have piled up. And we'll all have to work smart. Perhaps you have to look at trying to settle matters, instead of litigating every single case. Be selective. Be selective on how and what you want to litigate in court. Work smart.
And Puan Susila, what would you say were some of the challenges you faced when dealing with counsel at the industrial court when you were chairman?
After a period of time, we were also subject to productivity. Not only the employee in the private sector has to prove that he's productive, even chairman will have to show that we have spent a fruitful day. You see, there's expectation and there is accountability at different levels. First, as chairman, we are accountable to the president. And secondly, at the Ministry of Human Resources, they do look at statistics. And it doesn't augur well if out of 21 courts, some courts are moving slower and some courts are able to achieve some statistics. So there is a bit of expectation on all chairmen, and amongst the chairman, the president would discuss with the chairman what should be the target for the year. I think it used to be 72 cases at one stage when I was there. So we'll have to achieve 72 cases, and you may have experienced ways and means chairman would try to get the 72 cases and 72 cases disposed of, So some will, then we also have time charts where the time which we sit, because now everything is now recorded already, thanks to computerization. It's very transparent, how much time the chairman utilizes in a day. So if the court is not in session, it is reflected in our reports. How many hearing days were completed in a particular week or day or year. So the utilization of the hearing time is also important. So if you fix, some may fix one case and the case gets postponed. Some may fix 5 cases. Now, if 5 cases are ready to go on, then invariably one case has to be stood down. So these are the things which the chairman has to grapple with. So I used to try to accommodate counsel because we are in control of our dates at the point of the mention, and I would allow counsel to offer their dates. So we would try to fix whatever was suitable for all parties. But come the day of the hearing, many things could have happened. One, somebody along the way could have fallen ill. Number 2, very often it does happen, counsel in charge has to appear in another court, in the High Court, or as Ms. Janice had pointed out, somebody else from the firm has to step in. So these are the challenges I think law firms and the courts will have to overcome. We don't have a synchronized diary for the entire judicial process, but at the back of my mind has been this wild dream that if we can have one common diary for the entire court system, from the federal court, Court of Appeal, High Court, and all the tribunals, then we won't have this clash of dates. So it takes a lot of imagination to want to create such an environment. But I think if we all are of one mind, we can work towards it. But I would encourage people to also opt for ADR methods, mediation, negotiations, right? And we introduced early evaluation in courts in 2010. So that's another aspect which y'all can explore. Work jointly with the courts. I think the best thing is to find out what are the expectations of the courts, what are the expectations of counsel, and come to and work together. That's the best approach in the administration of justice. Bench bar and also the trade unions and the employers' organizations. There are structures, the meetings which you all have. These are the places where you can explore, new ways of doing things.
Thanks very much, Susila. Sal, if I can just turn to you, what would you say are the 3 most effective ways counsel can present his case or her case in the industrial court?
Okay, I would say first, it is important to sort of distill the material facts. Very often, right, when we are counsel, the client gives us, basically vomits the whole lot of facts on us, and we shouldn't drown in it. We should actually be able to sift through it and decide what are the material facts so that we don't waste everybody's time, most importantly, the court's time, in trying to, lead evidence on everything, and then in the course of it, drowning in those facts. The second thing is to identify the issues that make a difference. There may actually be many issues, but it is really important that you pick, the 2 or 3 most important issues and convince the court on those. Not again, flood everybody with so many issues. Of course, when it comes to things like constructive dismissal and all that, and we're talking about accumulated conduct, it matters. But in many other cases, 1 or 2 issues are the ones that make or break your case. So focus on it. Don't get swept up in the thing and feel that you got to convince the court of everything. And the third thing, I think that I cannot say enough about, it may sound like a record. I keep saying this to my juniors, and I'm sometimes invited to speak to your student associations, is use clear and precise language. Be very clear about what you're saying, why you're saying it. Do not, say things in your submissions that are ambiguous or that can be interpreted in a different way. I sometimes am served with submissions from the other side, and I actually think, aha, thank you. Okay, thank you for saying it that way, because now I can twist it to my advantage. Be very conscious of how your words sound, whether spoken or in writing.
Thanks, Sal. You mentioned earlier that you were exposed to other forms of practice, like medical negligence and even conveyancing as well. Would you say that there are styles of or forms of advocacy that are unique to industrial court practice that may not be evident in other areas of the law?
Well, perhaps there are. I think industrial court cases tend to be very fact-centric. Small difference, which is why sometimes, right, you find that clients will look at the case report and say, oh, here is the case that supports, me, we definitely must win the case, or conversely, we're definitely going to lose the case. But that's never the case, right? Because in industrial court, it's very fact-centric. So I think that's the big difference. And because of that, advocacy becomes very important because it is how you persuade the judge to accept your case, how you persuade the judge to see the facts in a way that is helpful to your case. And I think that the industrial court is a very, very good training ground to hone your advocacy skills, because that is where you really need to take all the minute details and string it together in a way to convince the court. The other difference also I find is that it is the one court where, you know, the judges are not caught up in unnecessary legalities and technicalities. They really have the bigger picture in view. And often I feel it is the one forum where true justice is done, you know, because you're not really, it's very different from civil courts where people are always jumping up and down and saying, oh, you know, object to this, object to that because of this, that, this rule, that section and everything. Whereas, sure, it happens in the industrial court. I'm not saying it doesn't happen, but often, you know, everyone has the big picture in mind. And that's very valuable when it comes to advocacy, because you're then not grasping at straws to win your case, but you also need to be a good advocate to really win your case on the merits.
Thanks, Susila. If I can maybe pose that question to you as well. You earlier mentioned that you were for a very long time in the judicial and legal services. Do you think that there are unique forms of advocacy applicable only in the industrial court and perhaps not in other civil courts?
Certainly, I think the tone of the cross-examination of counsel is definitely much softer in the industrial court. Once I had a lawyer with a criminal experience, and he was doing a cross-examination in a industrial relations. He scared the wits out of the witness. You see, the tone of the voice of counsel, see, and there's no need to develop that kind of stance in the industrial court. It is adversarial because it's litigation based, but it's not a matter of life and death, you know, where the veracity and truth, of course, they shouldn't lie, but you have to establish the truth of the matter in a criminal. So the tone of voice is the one that distinguishes. So some lawyers have had, you know, a multifaceted career, so they will be able to move from one environment to another environment. But definitely there is a difference in how the whole approach. I think it's more gentle in the industrial court. Somehow there's this feeling that we all have to maintain harmony in the industrial court. And nowadays with a computerized environment, everything is recorded. I think whether it's in the civil or criminal courts, everything is recorded. So we don't want to have, you know, dramas, high dramas in the court anywhere.
Yeah. Greg, can I just ask Puan a question? I was going to keep this till later, but since you've mentioned it, I always wondered, judges and of course industrial court chairmen make decisions, and one of the factors that weighs on your decision making is also demeanor of the witnesses. Now, I want to ask you, how much does the conduct and demeanor of counsel affect your well, I don't want to use the word prejudice or prejudice against them. How much does it affect the way you feel about a party, or does it affect it all?
You see, this is a personal trait. Okay, but I think anyone who has been schooled in the law realize that courtesy is important. Similarly, sitting on the bench, right? We are schooled in the law, and there is a way of conveying a different opinion. So the phrases, you know, phrases that we learn along the way are used. I strongly object. without really having to pound your fist on the table. So I think generally I will say lawyers are courteous. If there's any sign of agitation, they will know how to calm themselves before they start the case. Nobody participates in a hearing if you're feeling agitated. Maybe in an extreme case, you had, met with an accident somewhere. Certainly, the court would postpone. If you do not have the frame of mind to conduct a case, inform the court. You can always meet the chairman in chambers in the presence of the other, and inform the court if you have a predicament that day. Somebody in the family could have fallen ill and you cannot focus. We receive all kinds of news every day, especially during the COVID-19 period. We were receiving a lot of distressing news, So just inform the court and seek an audience with the chairman. Always if the other side is not present, then normally the court interpreter will be present and inform the chairman if there's some pressing matter. But generally, I think parties who come to court are very courteous. Perhaps the chairman sets the tone.
Yeah, possibly.
There could be high drama once in a while. I mean, I do hear of colleagues. I hope they've not flunked, but some people. Maybe it's an interaction of personalities. These are the dynamics. Maybe it makes life more interesting when everybody is, has a different way of managing a case. I think it's the dynamics of the interaction between the bench and counsel or a trade union rep who represents. But the rapport is really established during the mentions. Let's say you're appearing for the first time, you would have done at least one or two mentions before the chairman, and that's the way really of breaking the ice, right? From experience, it's not really so cut and dry, so learn to establish a rapport with chairman, especially new chairmen who come in, maybe some DPPs who are now sitting on the bench. They may expect a different kind, but I think as counsel, I noticed that you also have a part to play in engaging with the bench in a professional way.
Now, Puan Susila, you mentioned that it is good to create a rapport with the chairman during the mentions. Now, is there anything else that while you've been on the bench for so long, what you would have expected of counsel? I mean, courtesy is one thing. Like, what sort of traits?
You see, in industrial practice, we don't have these issues of suppression of evidence. That is very serious. So you see, ideally, you should present all the evidence in your favor and against you. That's the ideal situation, so that the court can even facts in support of your client's case and facts against your client, and invite the court to make an assessment and say why this is the better version. That's the idea. That's how the premise of establishing the truth of the matter should be, right? There should not be any suppression of documents which are not in your favor. So that's how we enhance the integrity of the court process.
Okay,
as counsel, you will have to present your case to the best of your ability. As chairman will have to keep an open mind. It's very important not to have biases and prejudices. And this will be reflected eventually in the evaluation of the evidence and findings. And we always have the appeals where, if you don't get justice at the industrial court, you still can appeal to the High Court, Court of Appeal, Federal Court. So I think that helps to maintain the integrity of the court process, that there are different levels where you can review the proceedings in the court below or tribunal below.
Thanks, Susila. Sel, if I can pose to you a question on a vexed issue. and you alluded to this a moment ago. The industrial court, as you know, is a court of equity and good conscience. It is not bound by the strict rules of evidence. But many a time at the industrial court, objections premised on evidential matters are raised, such as the admissibility of a document, the maker is not called. How would you reconcile the two competing schools of thought? The fact that the industrial court is meant to be a court of good equity and good conscience, and at the same time, these are a number of objections raised are raised based on rules of evidence.
I don't know the answer to that.
See, a decision maker, be it a tribunal or court, when receiving evidence, is it okay?
Yes.
Yes, Puan, please carry on.
Yeah, when receiving evidence, we'll look at three factors. One, is the evidence admissible? Two, is the evidence relevant? And what weight should be given to the evidence? The Evidence Act does apply to the industrial court. If you look at the definition of court in Section 3 of the Evidence Act, in E, it excludes arbitrators, but it includes any person who will receive evidence. And when we read it together with Section 29 of the Industrial Relations Act 1967, paragraph C, the powers of the industrial court include receiving evidence on oath or affirmation. So by virtue of this definition, the Evidence Act does apply to the industrial court. Then we also have Section 30, subsection 5 of the Industrial Relations Act, where the court must act according to equity without regard to legal form and technicalities. So this is the discretion which is given to the industrial court. So it is an exercise of judicial discretion whether to follow the Evidence Act strictly or whether to accept illegally produced evidence. You see, sometimes a party may receive emails as part of a chain, and he will not have access to a maker. So as long as you come to the tribunal with clean hands, I think the court will be more receptive about receiving such evidence where the maker is not available, but the information, the evidence has come into your possession from the other party. But if you use surreptitious means to record evidence by having hidden surveillance cameras, then it doesn't augur well. So the circumstances of the party's participation in obtaining that evidence is important. Come to court with clean hands. I think that is the line of approach the tribunal will adopt. But it is always the discretion of the decision maker whether to accept evidence which has been obtained in such a manner or whether the maker is not available. But it is relevant. Of course, now the weight to be given has to be considered. It's always a judicial consideration what weight we should give to the evidence. So we have also oral evidence, a witness who speaks in we talked about demeanor just now. I think it does matter. Certain people do have a convincing and more persuasive style of giving evidence. Somehow the body language does convey, or it could be a sign of nervousness. It could work the other way. A person who's so nervous about the environment, may be stuttering, but he may be speaking the truth. But I think when we look at evidence, we have to look overall in perspectives and see whether it gels with the whole case.
Thanks, Susila. Sel, did you have anything to add?
No, I think I would have said a lot of times the answer to that question is a very common sense approach. That's why people feel like, in this case, the court didn't allow it. In this case, the court allowed it. But I think the courts also can sort of look at it and feel like, where does justice lie? I mean, that's the sense I get, right? So.
Sure. Puan Susila, after the conclusion of a trial and after the written submissions have been filed by both parties, what were the steps you took in preparing your award?
You see, I would like to start on my award as soon as possible after the conclusion of the hearing, simply because the evidence and facts will be fresh in my mind. The longer I postpone, the harder it is will be it for me to recollect. And mind you, we are listening to about 60 to 70 cases almost simultaneously. So I would try to do it at the earliest possible moment. And then with my marker pen, I will look at the evidence. As see, at that point in time, I was still recording. I was still writing down the evidence. But by now, I think it would be a transcript. So the chairman may not be recording by hand and will be relying on a transcript. So even though I was writing by hand, I would still use the highlight to highlight certain important phrases, evidence or aspects of the case. Then, this is my secret, I use a mind map. I've got a set of colored markers and I do a mind map. I did attend a course by Tony Buzan. In fact, I persuaded the president of the industrial court to send almost everybody for that course. And I found it very useful, the mind map. So I use a mind map with a lot of colors, and there's a technique in doing a mind map. So at that course, I use it to plan my holiday. And it was one of the most organized holidays. So you see everything on a sheet of paper, what I would want to do, instead of just going with the flow. So when you see everything in one sheet, then it's easy to type in. Then by the time I was in the industrial court, we were already given computers. So we'll have captions, background facts, issues, evidence, findings, relief, remedy, whether the case has been proved on the balance of probabilities. Then with that draft, I will send it to my PA. I still hadn't done the formatting at that point in time, so I leave it to my PA to do the formatting. And then I get the first printout, the hard copy. So that I will do first thing in the morning, the editing, because then I can really see where the mistakes are. It'll be mainly typing mistakes or grammar. And depending on the complexity of the case, I might look at 2 or 3 hard copies. But I'll do the editing first thing in the morning, this time with a pencil or a red marker. So I used to be able to, I was very good at managing my time, because that was the first thing I learned very early in my career. How to do what you want to do, right? So I've been quite organized. So I always used to complete my awards within a month, though the time frame was 3 months given to us. So I think once you find your rhythm, there's a bit of discipline involved in whatever you want to do, you should be able to accomplish targets.
Sure. And Puan Susila, what would you say are the 3 most important attributes of effectively written submission at the industrial court, post-trial submission?
Remember, you are writing a brief, you're not writing a thesis. It's a brief. So I learned from law school, from my law lecturer, how to write a brief. It must be concise and precise. And the use of captions are helpful, right? So we normally go by issues. These are the issues, issue 1, issue 2, issue 3. What is the finding in favor? What is the evidence in favor? What is the evidence against? And when you're quoting cases, I always advise counsel, you need not quote verbatim. As long as you give the case citation, most of the cases we will already have our own copy, so you need not even photostat and send over. Just mention the case citation, what page, what paragraph. That's how I'll advise counsel. So that it doesn't mean that the thicker your written submissions, the more effective. In fact, get to the point, get to the gist of the matter. What are the issues?
And Sal, what would you say are the most effective ways of writing a written submission post-trial?
Okay, so I don't know if it's the most effective way, but the way I do it is I read the pleadings again. I feel that this is very important. A lot of times by the time we get to the point where trial is over, we've gone through a lot, and it's a very good idea to go back to the very basis of our case. So that's why I read the pleadings again. And then I have a system where I take one sheet of paper for each issue. So I write down, what the issue is. Issue A is this on one sheet of paper, and the next one, and the next one. And then below, on that same sheet of paper, I then start writing down the relevant facts and the evidence that has been led in respect of each issue. So I do it that way. And then, so I've got it all like a snapshot view of each issue and what I have going for my case and what I have against my case. So like I tend to divide the paper into two as well, right? And then I start to craft my submissions. And then naturally, pick the decided cases that will support the decided authorities that will support my case. Now, whether I start with my strongest point first or my weakest point to sort of get it out of the way and then finish with a bang, that I have to say I chop and change depending on what the case is about, depending on what kind, which I feel will be better on that given day.
Thanks, Sal. Jan, would you like to contribute as well? What would you say are the effective ways?
No, what I was actually going to say, following from what Sal said, is for those of our associates who have attended the Bar Counsel Advocacy Training, what Sal just said in respect of looking at the facts that are in your favor and that's not in your favor, this is the entire case analysis exercise, which is so critical to preparing for a case and also preparing your submissions. So you then know exactly what you need to highlight and what you need to not hide away from, but also to deal with things. We always say don't hide away from facts that are against you. Yeah. Now, Puan Susila, you in your years would have come across written submissions that are super voluminous and some that are very short and simple. And I remember when I first started practice, we used to go to court with really thin files where the pleadings were just in 2 or 3 pages and the bundle of documents was so thin. And now I find myself taking volumes and volumes of documents to court. What are your thoughts on that? What do you think has caused this practice to change? Because everyone used to say that IR practice was the easiest and it was the most, relaxed. But I feel that some of the trials that I do now are almost as heavy as some of the high court trials that my other partners do. What do you think about that?
Yeah, you see, the trade union leaders, representatives, they find it the most difficult to cope when you have so voluminous documents. Number one, if it's documents which are relevant, fine. If it's not relevant, don't include. Because it's not worth the wastage of, ink and paper to photostat documents which are not relevant. Identify documents which are relevant. Something which is now not being practiced is the filing of agreed bundles and non-agreed bundles. Each will file their own bundles and it may be the same documents. And normally, I would be asking counsel, please try to find the time to discuss and look at each other's documents. I hope if this practice returns, then you don't have to file the same documents, both sides. Number three, I think by now, e-filing is already being practiced in the industrial court.
Yes, it is.
Right? So what you should do before the start of the hearing, mark your documents. It should be on a different day. Then it doesn't impede the hearing as it goes on. Mark your documents, and that's where you learn to identify documents where you agree on the admissibility and even sometimes on the contents. So if we start with this practice of managing the flow of documents before the hearing, then we don't have to, contend with so much of documents being introduced. The other thing is there's always a timeline for the filing of documents. It should never be done on the day of the hearing. It should never be done, but it's still being done. And sometimes documents are being tendered when the witness is in the stand. So all this leads to delay, because then we need to take instructions because counsel has not seen that document. That's a first-time counsel. So this is where I think case management requires some fine-tuning, both by the bench, the bar, and in the industrial court, the trade union representatives. So there are a lot of practices. We now have to enforce it, so that things move on smoothly, and you don't have to lug all these documents. I hope with e-filing, things will be lighter on the load for everyone.
Doesn't quite seem like it, Puan.
Okay. So we wait for Generation Y to move up. Let's hope. Undi 18 in Generation Y. I feel that's how the computerization, when I look at my young nephews, they swim with the tide. It's no problem. So I think it will come. So just be open. We must be open. Those of us who are senior, we're always learning something new about technology, but we find the right mentors who are probably our nephews or nieces to help us along. We learn, but I think we should not be afraid of technology. Embrace it and use it to an advantage.
Thanks, Puan Susila. Just a final question from me, and this is to both our speakers. Or what would you say to the junior members of the bar at our firm, insofar as steps that they could take to improve their skills as advocates at the industrial court? Puan Susila?
I will agree with what Selvamalar said earlier. The industrial court is the best place to learn. Do not let the lack of experience impede you in any way. It's the best place to learn. I started off my career in the federal court as federal counsel in 1979. That's how it worked in the Attorney General's chambers. We didn't have a large pool of officers. I was just given the file and I was quite happy to go to court. So it's the same, whichever court you go, whether it's a federal court, court of appeal, high court, industrial court, it's the first case that you do, which is most important. And don't say no. Don't say, I don't have any experience, I don't know Maha Malaysia. Don't worry, just swim along and you will find your feet somehow.
Thank you, Puan Susila. Sel, how about you?
I think the most important thing is to really know your case. Understand what your case is about, what you want to convince the court of. And the second thing is, I think you cannot emphasize enough the language proficiency, because you've got to use your language effectively to persuade the court. If not, you can have a strong case, you can have all the authorities, but how are you going to persuade the court? And thirdly, I want to share something that actually a judge, retired federal court judge Jeffrey Tan, said, but at that time he was sitting in the Maha High Court. And there was this matter where it was a very senior lawyer, so I'm not going to mention his name. He was cross-examining the plaintiff's witness. And the judge just stopped him and said, I don't understand what you're doing. He said, please paint a picture for me. At the end of the day, your job here as counsel is to make me understand what your case is. So ask questions where I can see, and it was quite, I mean, if I was the other lawyer, I would have been very embarrassed, but the judge's exact words were, when you are in court, paint the picture for me. So if you're painting a scenery, I must be able to see, he said, what is forming. I must be able to see that the tree is coming up from the roots, the branches, the leaves, the birds flying above, but what now I'm hearing is I'm seeing one feather of the bird, and then I'm seeing one leaf here. I'm seeing, you're just all over the place, he said. And I think that's really important. At the end of the day in court, to be a good advocate, you need to paint a picture, and a picture that is believable and that you can sell to the judge.
Thanks, yeah, that's very helpful. So I think I've come to the end of my questions. I would just like to open up the floor to the rest of the firm, some of our associates or even Ken and his associates, to pose any questions that you may have to our speakers.
Can I just share a bit of my experience? It's not in your list of questions, but I'd like to enlighten you on what I actually look for in an industrial relations matter. I will look at the order of reference by the minister and scrutinize it. Has it been signed? Is it dated? If there's a date of dismissal, what is the date of dismissal? But one thing which I learned to appreciate very early in industrial court was the legal entity of the employer. See, the employer in most of the dismissal cases is a company. Maybe 90% of the cases is a company. But I did come across in very interesting variations where a Hindu temple, which was registered as a society, had dismissed a priest. So I became very conscious of looking at the legal entity of the employer. The employee is always an individual, or if it's a trade dispute, it's a trade union of workmen. Then the other thing which I noticed was the use of brand names in hotels, in hospitals, and in schools. So the letter of employment carries the brand name, but the legal entity may be an incorporated company under a different name. So I used to make inquiries about what was the legal entity of the employer. So pay attention to these aspects. It's quite interesting when there are variations to the team.
Actually, I had a further question, and it's to do with the recent amendments to the Act, the Industrial Relations Act. And perhaps the main amendment is the incorporation of this appellate process. Instead of filing a judicial review, one has to file an appeal to the High Court. Do you think that would have a good effect, a positive effect on the awards?
See, as far as I remember, that has always been the thrust of what the bar has wanted. And finally, I think they've got their wish. The process prior to this was by judicial review of an award. And judicial review should have been on very limited grounds, error of law on the face of the record, but never on facts. But there became a trend when the courts were, the High Court was looking into facts and finding that findings made by the industrial court were perverse. And more and more they started to function like an appellate court. So they were already scrutinizing the findings of fact of the tribunal rather than looking at, along the way, one of the recent Court of Appeal judgments, they said, no, we will not look into the findings of fact. But by then, I think the amendments were already in the pipeline, and now it's an appeal procedure. So definitely it will open the floodgates. You can always have a re-amendment and revert back. See, that's why you see now, as an administrator of justice, right? Number one, we are looking at the workload of the courts. Can be coped. So that's where the statistics become important, right? Starting from runner cases, should such cases be litigated? So ultimately, we are looking at the resources of the court, right? And is it the best way of resolving a dispute? That's why the ADR may gain traction again, may gain. I know in certain jurisdictions like the US and all, that is the mode. So I think we constantly have to look at the bigger picture. What are the resources we have? How much of delay can we endure, right? Justice delayed is justice denied. Justice hurried is justice buried, right? And ultimately, we all have a lifespan. There comes a time when we cannot handle the workload. So have a holistic picture of the system, the legal system, where we are in that system. The industrial court is there, having its role to play, but it's meant to be a tribunal to take away the load from the mainstream courts, the superior courts. But now we've added to their workload.
Thanks, Susila. Could I just maybe ask our associates if they had any questions to our speakers? Jan, did you have any questions of your own?
No, I shared my thoughts through the session, so I don't have any questions left.
Okay, I think it's 6:20. We have taken up plenty of time from our speakers. Thank you very much. On behalf of the firm, I'd like to thank both Puan Susila and Ms. Sel as well for their time this evening and for sharing with us their thoughts, which are sure to benefit all of us at the firm. Thank you so much. Thank you so very much. Hope to see you all soon.
Thank you.
It's been my pleasure, Greg, Janice, and
Thank you, Puan
Selvamalar.
Susila. Thanks for chatting with us, Sel.
Thanks.